Welcome to the final LitWRC Law, Technology, and Warfare Research Cell webinar of the year 2022. Very exciting to have reached the end of another year of excellent webinars in space law content, as well as expansions to LitWRC's cyber and emerging technologies departments as well. So thank you all so much for being here with me this morning for our final webinar of 2022. And I hope that you will join us further for additional webinars on all of these topics in 2023. So without further ado, let's go ahead and get started. You might have been expecting a big name space law expert, but it was me, Dio. No, just kidding. It's me, Major Jeremy Grunert from the United States Air Force Academy. You have likely, if you have watched these webinars in the past, heard a little bit about me and who I am. I am an assistant professor at the United States Air Force Academy and the United States Air Force JAG. I've been in the JAG Corps for about 9 years at this point, and I've been very privileged for the last several years to be teaching here at the Academy, teaching both the Law 220 kind of introductory law for Air Force officers class, and of course the new space law class that we've been developing here at the Academy, which is a lot of fun. And so very privileged to be doing that. And it looks like probably this is going to be my last year here at the Academy, and then we'll go on to something else as we JAGs very frequently do. So again, this is me, and standard disclaimer, while I am here in uniform presenting this LitWRC presentation to you, none of my comments should be construed as the official position of the United States government, the Department of Defense, the Department of the Air Force, or even the Air Force Academy itself. I'm appearing in my personal capacity as an academic, and so please do not take anything that I say necessarily to be the official position of the United States government or any of those other organizations. Of course, with the exception of if I am perhaps quoting an official policy that has been put forward by the United States government or one of these other organizations as well. All right, so 2022 in space law. To understand 2022 in space law, we have to go back all the way to last year. Last year, as you'll recall, I also conducted a 2021 year-end review of space law events that took place over the course of that particular year. And as we saw last December when I gave that presentation, one of the year's consistent themes was responsible behavior in outer space. Lots going on in responsible behavior last year, including the publication of the DoD's tenets of responsible behavior, including work at the United Nations, including work by the United States government, and indeed including work by us here at the U.S. Air Force Academy and United States Space Comm. As you'll recall, for those of you who might have been able to attend earlier this year, we were ginning up our U.S. Space Comm Legal Conference 2022, the theme of which was, of course, responsible behavior, examining those DoD tenets of responsible behavior. Now, it should come as no surprise that responsible behavior continues to be a very consistent and persistent theme of space law development in 2022. And one of the primary ways that this was occurring over the course of this past year was internationally at the United Nations. Here we have some pictures of the open-ended working group on reducing space threats that met at the United Nations several times over the course of this past year. And so just as a quick review, as you'll recall, this is something, again, we talked about at the end of last year during our review session. The United Nations First Committee created an open-ended working group near the end of last year, basically giving it the responsibility to meet and discuss these issues of reducing space threats, primarily through discussions of responsible behavior and how outer space law could be further developed, or how norms of behavior for actors in space could be further developed. And so you see here, right, on this particular screen that we talked about last year, the original UN First Committee resolution giving these responsibilities to the open-ended working group. Now, as the open-ended working group began its work near the beginning of the year, of course, one of the first things that a United Nations organization has to do is fix its agenda. And so it should come, again, as no surprise, right? Comparing these two things, the resolution, giving it its responsibilities, and then its agenda, that its primary agenda responsibilities mirror what the UN told it to do in its original first committee resolution from November 2021. So if you take a look at the agenda that was created by the OEWG back in February of this year, you'll see that what it is primarily there to do is a couple of things. If you look at paragraph 5, you can see that there's a general exchange of views between countries. We'll get to that again in a little bit. But primarily what it's doing is it's considering the things that are laid out in paragraph 6. It's there to consider these particular issues, these 3 issues that the first committee had previously specified in its resolution of November of 2021. And those 3 issues are these, right? To take stock of the existing international legal and other normative frameworks concerning threats arising from state behaviors in outer space, to consider current and future threats by states to space systems and actions, activities, and omissions that could be considered irresponsible. And then finally, to make recommendations on possible norms, rules, and principles of responsible behavior relating to these threats, and to discuss, right, how these could contribute to the negotiation of ultimately, perhaps, legally binding documents, including treaties, perhaps, on the prevention of an arms race in outer space. And so what you can see from the agenda and what you can see from the previous first committee resolution is a little bit of a compromise, right, between the 2 groups of countries operating in the UN. On the one side, right, Russia, China, and some of their allies who are very, very openly advocating binding international agreements, binding treaties to govern these sort of space threat issues. And on the other side, right, the United Kingdom, the United States, and many of their allies who are advocating the development of behavioral norms in space to really govern state behavior, to get at what states are actually doing, but without the need to actually negotiate a binding treaty. Okay, so you can kind of see that what the agenda is stipulating here is the discussion of these non-binding norms, or these soft law, right, quote unquote norms, that perhaps over time, right, would result in a convergence of state views that could potentially lead to legally binding treaty documents. Now, after some fits and starts early on in the year, right, we saw how the agenda for the OEWG was created there in February on the previous slide. There were some kind of administrative and logistical problems that were worked out in early meetings, largely because of some objections that were raised by Russia and a couple of other states. Eventually, the OEWG did meet in several sessions, 2 primary sessions, one in May, one in September. The session that occurred in May was primarily discussing paragraph 5 and 6A of the agenda, right, which is let's go back and see was that general exchange of views that I had mentioned before. And then, of course, actually taking stock of existing international law and normative frameworks. And so a couple things, right, came out of that initial meeting. During the exchange of views, a wide range of countries discussed the idea that a kind of more comprehensive approach to outer space behavior was needed. And there needed to be a little bit more discussion and development of some of the key principles that, while possibly binding, right, in previously created outer space law legal instruments, have not really been significantly developed up to this point, right? So you can see in the second paragraph here on this slide, right, quoting directly from the kind of the document statement that was released by the OEWG with respect to this first session, many delegates there at that particular meeting, quote, considered that specific requirements that follow from the principle of due regard, right, that principle of due regard elaborated in Article 9 of the Outer Space Treaty, should be further elaborated, right, in the context of reducing threats related to space systems. So this idea of due regard, right, one that is a binding provision of the Outer Space Treaty, but one that has not really been given any firm definition or context over the course of the almost 60 years now that the treaty has been in existence. So in this discussion of exchanges of views, in this discussion of reviewing existing normative frameworks and binding international frameworks for space law, what you saw was a fairly widespread discussion of the need for greater clarity on some of these issues, right? And so again, you can see in this third paragraph here, many delegations considered it was important to develop common understandings of how international law applies to particular critical space threat related issues, right? Protecting civilians, protecting civilian objects, protecting the natural environment from threats that arise from state behavior related to outer space. And so fairly productive, right, first session meeting. You can go to the open-ended working group's UN website and read many of the documents that came out of that meeting, including statements from the participants, as well as kind of the advanced versions of the breakdown of the discussions, right, that the working group itself actually published. Now, the second session occurred in September, right there in the middle of September, 12 through 16 September 2022, discussing paragraphs 6B and to some degree 6C as well, right, which, as you'll recall, are considering current and future threats by states to space systems, and then, right, working on possible recommendations with respect to norms, rules, principles of responsible behavior. And on this issue of discussing space threats, breaking down space threats, there were a lot of very, very significant discussions, some of which I will return to shortly in our discussion of the war in Ukraine and some of the statements that came out of both the open-ended working group and later the first committee on issues related to that war. And so you can see here first on this slide and then proceeding into the second, some of the concerns that states raised with respect to space threats that either currently exist or are kind of continuously being developed and widening as well. And so many delegations, right, expressed specific concern regarding threats to critical national security infrastructure in outer space. National security infrastructure in outer space, obviously something that has played a very, very prominent role in state security since the middle of the Cold War, right? You go back to the Cold War treaties between the United States and the Soviet Union with respect to arms control, with respect to certain nuclear weapons caps and things of that nature, and the need for, quote, national technical means of verification. These national security satellites and space systems play a critical role for a wide variety of states in terms of giving them the information that they need, right, to make terrestrial geopolitical decisions. And so, of course, threats to this infrastructure are very, very concerning to a number of states, most states who use outer space, right, for those particular purposes. Now, there was also a discussion of how certain national space strategies, policies, doctrines could be perceived as a threat, right? So in this particular context, some criticism, right, of the United States and some of its national space strategies and policies and perceptions, right, of outer space as a warfighting domain, this idea that recognizing outer space potentially as a warfighting domain contributes to the types and number of space threats that could proliferate, right, in the outer space environment. A discussion really that has gone back to the earliest days of outer space activities, this question of whether outer space should be a sanctuary that's free from war and conflict, right, one that should really truly solely be used for quote unquote peaceful purposes, or whether based on its nature, right, and based on human nature, outer space would become another field of, right, military activity and military endeavor. So discussions of this question at the open-ended working group as well. Getting back to the space law development aspect of all this, the delegates discussed in the context, right, of paragraph 6B, the development of norms related to new technologies, economic development, and how, right, these norms could contribute to the safety of the outer space environment, even in the face of, right, some of these space threats that were previously discussed. So some ideas tossed around there. Again, a true emphasis on the need to preserve and protect outer space, right, for these very, very critical purposes, for exploration, for technological development, for economic development, and a recognition that outer space plays a key role in a wide range of countries, economies, economic activities, and national safety in a wide variety of ways. We'll return to this slightly later on in my discussion, but there was discussion of concern related to the testing of anti-satellite weapons and the attendant debris that is created through the use of those weapons. We've talked previously on this program, as well as in other fora, about how direct ascent ASAT testing creates very significant outer space debris, and we've seen this in a number of ASAT tests that have occurred over the course of the last 15 years, from China's 2007 ASAT tests, the United States Operation Burnt Frost in 2008, India's ASAT test in 2019, and most recently, of course, Russia's direct ascent ASAT test of November of 2021, right, just a little bit over a year ago. And so widespread concern and discussion about that particular issue at the open-ended working group, and further discussions as to how that particular issue could be addressed, along with some celebration and recognition of efforts that certain states have made. And again, we'll come back to this in a few slides, with respect to limiting those sorts of tests in the outer space environment. Further discussion with respect to space threats kind of covers ground that we've talked about in this program and in others, space threats related to rendezvous and proximity operations, and the fact that many of these types of operations can serve potentially dual use purposes, right? The technology that can be used to conduct a helpful or repairing proximity operation with the satellite could also be used to damage somebody else's. So kind of treading similar ground in terms of the dual use discussion for some of these emerging technologies, such as rendezvous and proximity technology and other things of that nature. Now, shifting slightly from the open-ended working group to something that has really been at the forefront of international geopolitics in the year 2022. Of course, we have the Russian invasion of Ukraine, which began in February, right? 24 February, Russian troops crossed the borders of Belarus and Russia into Ukraine, beginning the ongoing invasion, right, that has been continuing on for the past 10 months and will continue for the foreseeable future. So lots has been said, lots has been written about the war in Ukraine. So we're going to focus in on the kind of key space law aspects of the conflict, of which there are many, as those of you who watched this webinar may have previously heard or have tuned in to some of the other programs that both I and many of our other guests have been on in the course of the past year. Or if you, for example, have been following the Lieber Institute's Articles of War and their ongoing written discussion and publication on this particular conflict. There are a lot of critical emerging technology issues, many of which are directly related to outer space. And so among these issues is this question of civilian technology use in international military conflicts, right? And so even before the Russian invasion, you had civilian companies, civilian remote sensing companies like Maxar releasing remote sensing imagery to show things like troop buildups by the Russian military, both in Belarus and in Russia. And then, of course, after the conflict actually began, you've seen a wide array of commercial actors contributing, whether it's communications infrastructure, whether it's satellite imagery, whether it's other remote sensing, right, technologies or imageries, and various other critical military technologies that are space-based to the ongoing conflict, primarily on the Ukrainian side, right? And so here on the screen, we just have screenshots of a couple of articles, right, discussing this particular issue. But it is a very, very critical question that a number of people have raised, and that has been raised now by the actors themselves and the UN, as we'll discuss here in a couple slides. What is the significance and what is the international legal significance of these commercial space actors participating in conflict in this way? And of course, right, in addition to the remote sensing imagery provided by Maxar and ISAT and many others, right, one of the more prominent examples of this came very, very early on in the conflict, when Elon Musk and Starlink agreed to send Starlink terminals to Ukraine. Now, of course, Starlink had already been working with the Ukrainian government with respect to getting Starlink services started up in Ukraine prior to the invasion, right, from a commercial sense. But all of this was extremely fast-tracked after the Russian invasion. And of course, right, very, very famously, you had that Twitter exchange that's there on the screen between Mikhailo Fedorov and Elon Musk, in which, right, Fedorov specifically requested Starlink services and Starlink systems to be sent to Ukraine. And Mr. Musk replied that he would send them, and did, right? And so, again, very much like the remote sensing imagery and other kind of satellite-based technologies, this satellite provision of communications and internet that could keep the Ukrainian government going, even when Russia was targeting their critical communications infrastructure, played a very, very critical role, and continues to play a critical role in the conflict. Now, from a space law perspective, right, like I said, this raises some very, very significant issues, right? So we have issues related to Article 4, sure, but not really. For those of you familiar with the Outer Space Treaty, Article 4 is, of course, the primary kind of military-related article of the treaty that discusses and forbids, right, states from placing nuclear weapons or weapons of mass destruction in orbit, but largely in an orbital sense, right? If it's not a weapon of mass destruction, if it's not a nuclear weapon, then really the Outer Space Treaty doesn't explicitly prohibit it in orbit. Now, of course, the moon, celestial bodies, these are completely demilitarized, but that doesn't really pertain in the Ukrainian war context. So from an Article 4 sense, right, there's really nothing wrong from an international space law perspective with these companies doing what they're doing in orbit, in outer space, providing these military-oriented services, either to Ukraine or to anyone else. Now, the bigger question, though, is probably one that's raised by Article 6. And for those of you, again, who are familiar with the Outer Space Treaty, Article 6, as you know, does a couple things. First, it establishes that states bear international responsibility for their national activities in outer space. But, right, more importantly, it also stipulates that these types of activities can also be carried out by non-government entities, right? So unlike pretty much all other international law related international responsibility contexts, in the outer space context, a non-government entity and a non-government action could actually trigger international responsibility as well. And so this is one reason, again, that Article 6 also requires that state parties who allow non-government entities to operate in outer space are required to both authorize and to continuously supervise their activities, which is why the United States, just like many other countries that do this, has national space laws to regulate its commercial space actors. So what does that mean in the Ukraine war context? Well, what it might mean is that private companies such as Starlink or Maxar or any other outer space-based remote sensing, satellite communications, or other technology company that is licensed in the United States, right, could be maybe, right, under the Outer Space Treaty, drawing the United States further into the conflict because their actions trigger international responsibility for the state party, i.e. the United States, that authorizes and continuously supervises their activities. Now, others have discussed the possibility that behavior by these private actors could also compromise perhaps the United States neutrality in a conflict of this nature. This is certainly possible, right? We don't have time to dig into all of the kind of deep international law of war questions that define neutrality in this particular webinar, right? I could give an entire webinar, and many people could, right, just on that particular question alone. But is it possible? Sure, yes, it's certainly possible that neutrality could be implicated by some of these behaviors, although, right, there are Hague Treaty provisions about, right, communications and things of that nature that would allow a state providing communications infrastructure and things to a belligerent in a conflict to keep providing that in the same way, perhaps, right, that they had done prior to the conflict, or as long as they're doing it kind of in an equal way with other belligerents as well. So we'll leave aside questions of neutrality, right, for the moment, because those are very, very difficult to discuss. But the point is, right, that again, based on these international outer space law provisions, what these commercial companies are doing is unique and, right, at least under Article 6 and some of the other provisions, could actually implicate, right, state activity, right, and international responsibility for that state in their particular activities in regard to the Ukraine conflict. So for more on that, right, check out the Articles of War Liber Institute blog. A number of people have written about that, both there and in other places as well. Now, the second issue that's raised by this use of commercial remote sensing, communications, space technology in the conflict is a law of war one, right? So we've kind of talked some general international law, we've talked international space law, but there's also a law of war implication to this as well, right? Because the war in Ukraine, despite, right, its central illegality, right, the aggression of Russia invading a sovereign state with no, right, significant justification for doing so, despite its underlying illegality from that particular sense, it is an international armed conflict to which all of the international armed conflict rules and laws would apply. And so the Department of Defense, right, has settled on the terminology of law of war rather than law of armed conflict. So I will continue to say law of war right throughout the rest of this presentation, but international humanitarian law, LOAC, or law of armed conflict, right, any of these could be synonyms, right, for what we're discussing. But you take a look at the law of war, and in an international armed conflict of this nature, of course, you have your critical law of war principles that govern state behavior in the conflict itself. And some of those critical law of war principles are those here on the screen, right? Distinction, military necessity, proportionality, preventing unnecessary suffering, right? Chivalry, or the prohibition on perfidy. These are some of the, if not the key, like law of war principles that govern state behavior in an international armed conflict. And so you take a look at these a little bit closer, particularly from the first additional protocol to the Geneva Conventions. And you see that distinction, right, requires parties to the conflict, requires belligerents to distinguish between civilians and civilian objects and lawfully attackable military objectives. Now, this plays into military necessity because military objectives are not necessarily 100% military all the time, right? Military objectives are things which by their nature, location, purpose, or use make an effective contribution to military action and whose total or partial destruction, capture, or neutralization offers a definite military advantage. So between these two principles, distinction and military necessity, what we see is that belligerents in an armed conflict do have to distinguish, right, between purely civilian and military objectives. However, a civilian operated, civilian controlled target could potentially be a military objective. We've seen this in many conflicts over the course of history. And so, right, all you have to do is think about perhaps the invasion of Normandy to see how things like a bridge, a highway, a rail yard or a railway junction, railway tracks themselves, civilian trains, all of these things are not necessarily, right, military owned or operated, right? In fact, many of them are not. However, they can all provide a very, very critical military advantage, and thus targeting those things could be something that offers a definite and distinct military advantage, right? If you want to invade Normandy without the Germans sending in reinforcements, you want to cut Normandy off from the rest of France, you want to destroy the bridges, the railheads, the railway lines, the roads leading into Normandy, right? And the same principle is at work in modern conflicts as well. And so you can see from these particular things that the role of these civilian remote sensing, satellite communications, other space technologies companies could potentially implicate, right, some of those questions. If Starlink, for instance, right, a satellite-based communications service was critical in allowing the Ukrainian military to continue its operations, right? The Russian military might view Starlink systems as something that was providing a critical contribution to Ukrainian military action and might justify its targeting of the Starlink system on that basis under the principles of distinction and military necessity. Now, drawing in proportionality, right, that third law of war principle, things become extremely touchy in the outer space context, though. Proportionality in a terrestrial conflict, while not 100% straightforward, is at least theoretically straightforward, right? You have some sort of terrestrial target, you want to go and attack it, and you have to weigh and measure the military advantage over the expected loss, damage, death to civilian property and civilian lives, right? At least from a terrestrial standpoint, that's, again, fairly straightforward, even though, right, it's not something that we generally like to think about, and obviously has very, very dark implications. From an outer space context, though, the question of proportionality gets extremely complex because, as we discussed a moment ago in the context of the open-ended working group, the physical or kinetic targeting of satellite systems is liable to create very, very significant clouds of orbital debris, which can threaten all space actors, right? Not just the belligerents to a conflict, but in fact, right, any actor operating in the space environment, both neutral parties and belligerents, and lots of other people as well. Damage to other space systems can also cause, right, very real terrestrial harm. And so the destruction of remote sensing space systems or GPS systems that people rely on for financial transactions, for natural disaster detection and management, for weather, for all of these things, can have very, very real terrestrial effects. And so, again, a kinetic attack on satellite systems might, right, violate the principle of proportionality just straight up because of the wide amount of debris that is created and the persistent and continuing threat that that debris poses. Now, that's not necessarily something that has been firmly established under international law of war, right? Something that a number of academics have stated, right, that a kinetic attack on a satellite would always be disproportionate. Not 100% sure that that's necessarily true, but you can see the reason why. Now, even a non-kinetic attack on a satellite can also have significant implications, both in terms of limiting that satellite's service, whatever it is providing, which again could have terrestrial implications as well. And depending on the type of non-kinetic attack on that satellite, could turn that satellite itself into a piece of space junk, or could limit, right, the operator's ability to maneuver that satellite should it need to for some other reason. And so, again, very, very complex and extensive proportionality issues that might be related to some of this satellite targeting. Now, none of this has been lost on the Russians, okay? And so returning to the open-ended working group, right, on reducing space threats, back in September, you got a statement from Russia's head of delegation to the Office on Disarmament Affairs, Konstantin Vorontsov. Now, Vorontsov repeated his comments slightly over a month later at the UN First Committee. His first set of comments at the open-ended working group received almost no press coverage. His identical comments at the First Committee, wow, yeah, blew up, right? So you probably remember all of the kind of breathless articles near the end of October about Russia targeting space systems and saying that it's going to blow US satellites out of the sky and yada, yada, yada. Well, again, Vorontsov's comments in October were literally the same ones that he had previously made at the open-ended working group. So what did he say? Well, he said what a lot of, right, the academics and folks who had written about, right, the civilian space issue in Ukraine had previously mentioned, right, the problem of the use of these systems possibly making them targets in this international conflict. And so you look at Vorontsov's comments, and he very, very critical, right, accuses the United States, right, and Ukraine's Western allies of causing this problem, right, saying that what we don't understand, what the United States and its allies don't understand, is that the use of this commercial infrastructure is going to make it a legitimate target for, right, retaliation. We'd like to underline an extremely dangerous trend that goes beyond the harmless use of outer space technologies has become apparent during the events in Ukraine. The use by the US and its allies of elements of civilian, including commercial infrastructure for military purposes. Okay. There it is, right there. Something that the Russians recognize and something that the Russians were at least miffed about enough that they sent Vorontsov, right, to offer these comments at the open-ended working group, right, and then again at the First Committee of the United Nations a month later, right? And so you can see some of the things that they're pulling out here, right? They're now characterizing it as quasi-civilian infrastructure, right? Basically saying that the participation of these companies and the use of these systems for military purposes in this international armed conflict is chipping away, right, at their civilian protection. They're now quasi-civilian infrastructure that can become, he says, a legitimate target for retaliation. And so again, continuing on with his criticism of the United States, the United Kingdom, the West, right, the Western countries, he says, the Western countries have needlessly put at risk the sustainability of peaceful space activities. And now this is interesting too. Near the end of his OEWG comments, right, he says that this is either kind of at the minimum, a provocative use of civilian satellites, also claims that it's questionable under the Outer Space Treaty, right, which provides for the, quote, exclusively peaceful use of outer space. Very, very interesting, right, that he's characterizing it in that way, right? We've seen over the course of the last 6 decades, a lot of discussion over this question of what peaceful use of outer space actually means, whether it's exclusively peaceful use in the sense of completely non-military, or whether it's non-aggressive use in the sense that as long as it's not a weaponized system operating in space, if it's providing some sort of military support function that's not necessarily aggressive, right? Is that all right? Lots of discussion about that over the course of the last 60 years. And in fact, right, you go through the Outer Space Treaty, you see Article 4, there really is no specific international legal requirement, right, that space be used for peaceful purposes. You can go back to space law experts such as Ben Cheng, for example, who have written extensively on that question. Of course, it's mentioned in the preamble to the Outer Space Treaty, mentioned a couple of other places, but there does not seem to be any specific requirement, legally speaking, right, that space be used exclusively for non-military types of peaceful purposes. Okay. Anyway, that was sort of a digression. The point is, right, that the Russians have recognized what is going on and have themselves, right, been suggesting publicly at the UN that they view this in that very same sort of context under international outer space law, under the international laws of war, that these particular commercial space systems could, in fact, potentially be targeted. Now, of course, the Russians have not kinetically targeted these space systems in any sort of meaningful way, right? Certainly not in the sense of, right, some of the direct descent ASAT missiles that they are known to have, right, from such things as their ASAT test last year. However, there is evidence, right, and Elon Musk has come out publicly to discuss such things, right, that the Russians have been using non-kinetic attacks on satellites. Musk himself, right, again, very publicly discussed the fact that Starlink is constantly fending off cyber and jamming attacks on its Starlink systems over Europe and over Ukraine. So very, very interesting discussion, right, and one that is going to continue into the future as both this war continues in Ukraine and as other conflicts erupt, and as the use of satellite systems continues to be a prominent thing in conflicts in the future. All right, let's shift gears again to kind of another critical outer space law development in 2022. And this is another norm or responsible behavior related development, which is the movement towards an ASAT testing moratorium. So I've already mentioned the Russian ASAT test from last November a couple times. I won't belabor the point. Right, mid-November last year, Russians tested a direct descent ASAT missile, creating 1,500 plus pieces of space debris, very, very widely condemned at the time. Now, the United States was one of the countries that condemned the Russian test back in November of last year. And early on in the spring, right, in April, Vice President Harris was at Vandenberg Space Force Base and gave some remarks in which she expressed a new policy of the Biden administration, which was the idea that the United States would put a moratorium on testing of direct descent ASAT weapons. Now, of course, the United States has not tested a direct descent ASAT weapon in some time, right? The last example of kind of a direct descent ASAT used by the United States was actually not a test, right? It was the 2008 Operation Burnt Frost kind of response to the Chinese 2017 or 2007 ASAT test. However, right, this was something that a number of experts had discussed. Obviously, there were folks in the Biden administration who were discussing it as well. And so when the vice president gave these comments at Vandenberg Air Force Base, this was kind of the key kind of policy that came out of those remarks. And so you can see some of the things that she said here on the screen, right, critical of the Russia test that took place last November, characterizing direct descent ASAT tests as reckless and irresponsible, a danger, right, to what we and what everyone else does in outer space. And again, that announcement, right, that the United States is committing itself not to conduct these sorts of destructive direct descent ASAT missile tests. Now, she went on to say, right, and this is something that the United States will periodically say, but sometimes not say, right, the vice president explicitly said that the Biden administration intended to work with other nations to try and make this moratorium an international norm for responsible behavior in space, right? Something that would grow and expand beyond the United States itself, that would encompass other nations, and that could grow to become an international norm that might, right, over time, even become something more, right? Maybe something that would grow into customary international law, for instance. And just as the vice president said, right, over the course of the year, a significant number of US allies have signed on to the United States moratorium. And so, right, moratorium announced by Vice President Harris in April. In May, Canada became the first nation to join us in that moratorium. And from July through November, a wide range of other states have jumped on as well. So Canada, New Zealand, Germany, Japan, South Korea, the UK, Australia, and France have all agreed to join the United States in its moratorium on direct ascent ASAT testing. Now, of course, that's very, very significant and important and good, right? And these states choosing, right, to voluntarily bind themselves in this way is very, very significant. What might be even more significant, though, is that the Biden administration also pushed forward a direct ascent ASAT moratorium at the United Nations. And so first at the first committee and then later in the General Assembly, right, the United States backed measure was put to a vote. In early November, right, it passed the first committee overwhelmingly with 154 states in favor. And again, many of those states are states that are not necessarily even traditional co-voters with the United States on many issues. And so you can see, right, the states that were against the provision: Belarus, Bolivia, China, Cuba, Iran, Nicaragua, Russia, Syria, kind of that core group of Russia and China affiliated allies, as well as a number of states that also abstained. But a very, very strong majority there in the first committee for the direct ascent ASAT testing moratorium. Now, this was repeated a month later in the General Assembly itself, with one of the abstentions, right, Uganda, actually jumping on to vote yes in the General Assembly. And so what you now have is a very, very significant majority of states in the international community agreeing with the United States, right, that this moratorium on direct ascent ASAT testing is very, very important. And in fact, right, something that ought to be a goal of states in the international system. Now, of course, the UN General Assembly's resolutions are not internationally legally binding, but they are, of course, very significant in the sense that they offer a perspective on the views of states in the international community. And with such a clear majority of states, right, this is obviously a very, very significant win for this idea of direct ascent ASAT testing as being irresponsible and dangerous. And so what we've seen in the course of 2022, right, largely perhaps triggered by the Russian ASAT test of November of 2021, is that we have gone from, right, no sort of moratorium or internationally recognized effort to limit direct ascent ASAT testing to now, right, you not only have kind of a core group of countries that have signed on to the United States overarching moratorium, but a very, very clear majority of countries in the UN General Assembly recognizing that this sort of behavior is harmful and dangerous, right? So a very, very significant win for the Biden administration in terms of this particular development of international space norms. So those were kind of the three big blocks of space law development in 2022, but let's move on to a couple of additional things. And I see that we're coming up on 8:50. I do want to leave some time for questions. So we'll go through this pretty quick, and then we'll have some time, hopefully, for questions as well. So one of the continuing things that the United States and some of its allies have continued to develop over the course of 2022 is the Artemis Accords. Now, the Artemis Accords, of course, were first published in 2020, right? And so we're not going to go through the accords themselves, but of course, they are a set of principles and guidelines, best practices, right, to enhance civil exploration and use of outer space, right? So very focused, of course, on civil space exploration, not military, right, not necessarily commercial, although many of their provisions might apply in those contexts as well, especially provisions related to outer space resource extraction and the like. But in 2022, you saw a very, very significant expansion of countries that were signing on to the Artemis Accords to join the United States and, right, the other international partners who had already signed on to the Artemis Accords to essentially agree, right, to bind themselves to these sorts of principles, right? And so at the very beginning of the year, right, you had Israel sign on, Romania and Bahrain and Singapore in March, Colombia in May, France in June, Saudi Arabia in July. And then, right, back at the beginning of this month, a very, very significant development, right? The first African countries to sign on to the Artemis Accords, Nigeria and Rwanda, again, at the beginning of December 2022. So some very, very significant expansion of international partnership in the Artemis Accords, which of course will contribute to the development of these sorts of principles and norms, at least among the Artemis Accord partners. Building on some of the developments from last year with respect to Secretary Austin's publication of the DoD's Tenets of Responsible Behavior back in July of 2021, the Department of Defense also updated its space policy, Department of Defense Directive 3100.10, to encompass, right, some of the changes that had occurred over the past year and a half. So much of 3100.10 is, right, the same as it always was. DoD recognizes space as a priority domain of national military power, underpinning multi-domain joint and combined military operations to advance national security. Yes. And of course, many of the things that it calls upon the DoD to do are identical as well: preserving access to freedom to operate in the space domain, protecting, defending the use of space for U.S. national security purposes, the U.S. economy, allies and partners, etc. But very, very significantly, right, those responsible behavior provisions that were elaborated in Secretary Austin's 2021 memo have become a core part of the space policy itself, right? And just as a reminder, those 5 tenets of responsible behavior were these: operating in, from, to, and through space with due regard to others and in a professional manner, limiting the generation of long-lived debris, avoiding the creation of harmful interference, maintaining safe separation and safe trajectory, and then communicating and making notifications to enhance the safety and stability of the domain. Now, of course, Secretary Austin's July 2021 memo, very, very important, right, called upon the Department of Defense and its various agencies to do those things. But the actualization and inclusion of these tenets in the DoD directive itself really actualizes that memo. And so, of course, is a very, very significant development as well. In October, you saw the release of the United States National Security Strategy, which recognizes outer space, right, as another critical domain, and talks about the importance of integrated deterrence and integration across military domains, including the space domain, as well as in non-military domains, such as kind of the typical DIME domains, right? Economic domains, technological domains, information domains, etc. Speeding through it now, right? Again, it's 8:54. Want some time for questions. In October and November, we saw the completion of China's Qingdong space station. Of course, a very significant development, right, for China to create its own space station. And we've seen already some of the potential legal ramifications of that from, for example, China's note verbal in the UN at the end of last year about possible Starlink threats to its astronauts there in kind of its original space station modules. And so, right, remains to be seen, right, how the Chinese are going to use the space station. But of course, the continuous development of new space stations and new space modules and things of that nature also implicates things like the Artemis Accords discussion, perhaps of safety zones around these sorts of crewed space objects. And so, right, a very, very significant development and a technological triumph, right, of course, for the Chinese to have constructed a station in this manner. Finally, one of the last things I wanted to kind of discuss, just because it was interesting, even though it's not going to become US law during this particular year or congressional session because it's over, You saw the passage by the Senate of the Orbits Act, right, which is an act that is created for the sole purpose of controlling outer space debris, right? And so you can see its short title there, the Orbital Sustainability Act of 2022, or the Orbits Act. And basically this was the Senate, again, recognizing the significance of outer space debris in low Earth orbit and the threat that that debris poses to continued use of those orbits. And so this is really Congress's first attempt to regulate outer space debris in any meaningful way, right? And so you get a definition section where you see definitions for things like active debris removal, eligible entities of the United States, right? It's non-federal commercial entities, it's entities of higher education, et cetera. Definition of orbital debris, right? Very similar to the definition that exists in some of the United States other space policies. And then when you actually get into the bill itself, what it does is it creates this requirement for NASA to consult with other federal agencies to develop a program to actually remediate orbital debris, to find some way to reduce the amount of debris in orbit in a meaningful way. Now, we won't go through all of the various sub-provisions of the Act since we're running out of time, so feel free to go and read the full text of the Act. It's of course available on the congressional website, right, where you can find all of Congress's various acts. And so, again, just a very, very significant recognition by the Senate that orbital debris is a problem. And while, again, this was something that the House did not vote on prior to the end of its session, and so will have to be reintroduced during the next congressional term, definitely something that we want to continue to watch to see if Congress is going to bring this up again to try and pass another version of the Orbits Act later on. And so I was going to kind of try and create a graphic for you of, a spaghetti chart, a la some of those Afghan war charts, kind of connecting all of this. But I basically was feeling a little bit like Charlie Day. So just take my word for it, right? All of this outer space responsibility, these legal developments, they're all connected in very, very significant ways, right? Of course, military operations in space, including the use of kinetic targeting of space systems, can create debris, which can threaten outer space systems in any number of ways, creating both a military space threat and other harmful activities in outer space. It really, all of the developments that we've seen over the course of the past year, and really beyond that, looking back into the recent past through the Obama administration, the Trump administration, and now the Biden administration, this push for the development of norms of responsible behavior by the United States and its allies, really an attempt to address some of the key underlying issues that continue to exist and that haven't been completely elaborated under existing international outer space law. And so with that, before we get into questions, I just wanted to offer a final kind of shameless plug for those of you who haven't already registered. LitWork is once again partnering with US Space Command to help co-sponsor its upcoming annual legal conference. The US Space Comm Legal Conference 2023 is going to be held between 28 February and 2 March here in 2023, obviously here in a couple of months. And it's going to be in person, live here at the US Air Force Academy for the first 2 unclassified days, and then at Schriever Space Force Base, I believe, for the final classified day of the session. That will be streamed via Zoom as well, so if you can't attend in person, we would welcome your attendance virtually via Zoom. We'd love to welcome you to the conference in that way as well. The theme of this year's conference is cooperation in outer space. And so we will be having a number of keynotes and panels related to this topic, addressing both international and commercial cooperation between the United States government, the Department of Defense, and its key international and commercial partners. Now, for that final day of the conference, March 2nd, again, will be held at Schriever Space Force Base, and it is going to be at the releasable to 5I level of classification, probably, possibly subject to change. That's the goal now, though, to make it top secret, releasable 5Is. And so if you have any other questions regarding the classified day or the classification level, please contact Lieutenant Colonel Joshua Wolf. His email is here on the screen, joshua.wolf.4@usspacecom.mil. I've thrown a registration link for the conference into the chat box here during the webinar. It's also here on the screen as well, although I know that that's a very lengthy slide, and so I'll send it out again before this webinar is over. But we really do look forward to welcoming you to the conference. And there at the bottom of the slide are our two keynote speakers, Professor Lori Blank and Mr. Tom Ayers are going to be our keynote speakers for the first and second day of the conference. So we're very much looking forward to that. And we hope that you can join us as well. And so now I will go ahead and stop sharing and begin taking questions. I see that some have made their way into the chat box. First question, will we be able to get a copy of the slides? Yes, I will send out a kind of a PDF copy of these slides, especially right for those of you who might be seeking to use this for CLE. Definitely more than happy to provide you with a copy of the slides. So I will send those out to our mailing list. If for whatever reason, right, you've jumped on the webinar and you're not on our mailing list, please just shoot me a message. I'll throw my email into the chat box as well. And you can just email me and I'll send you a copy of the slides. Mr. Meyer asks, how can we develop a legal framework to recycle space debris instead of burning this worthful materials in orbit for an on-orbit ecosystem? Very, very interesting question, Mr. Meyer. A number of people have suggested, right, that existing outer space debris could provide some very, very significant and valuable, right, scrap, precious metals, all of the various things that have gone into developing those systems. Why burn it up? Why waste it when we could recycle it? I believe that one of the problems is simply the exact same problem that we have just when discussing generic debris cleanup, which is how exactly do we do it, and will other countries necessarily allow us to do it? Not us in a United States sense, but just us in a, right, whoever is operating these sorts of active debris removal systems sense. Right, there are a lot of legal questions involved in, right, especially kind of registration convention, international space law, who continues to own and control those sorts of pieces of space debris. And to the extent that they are valuable and to the extent that they could be recovered, would that particular country perhaps have first dibs on, right, the recovery of those valuable materials, right? Would they have to pay a finder's fee to the organization that could actually recover them? These are all very, very difficult questions, but of course limited by the fact that at least at this time, there's not currently any sort of technology that we have in any sort of meaningful sense that could recycle the space debris or bring it back to Earth in an economically viable fashion, right, to recycle it. That said, again, very, very critical question, and one that's obviously very important to the extent that we could develop technology to recycle those systems. That would, of course, be very, very beneficial and far more sustainable for the outer space environment. Let's see, Ms. Cho asks whether the open-ended working group has representatives from private companies. Yes, and I think really the answer is yes. There are a number of non-governmental organizations and others who have appeared and made statements at the open-ended working group. Now, I'm not aware of, at least on the open-ended working group's website, I haven't seen any, and I'll pull this open because I think I have it here right now. I haven't seen any statements that have been issued by commercial actors, or at least not purely commercial actors, right? Certainly you have some government, some quasi-government commercial organizations that have maybe offered some statements, but none from specifically commercial actors. So I think that the answer is there are certainly commercial entities that I believe have been attending the sessions and have been watching the OBWG very closely. I'm not really sure that they are participating in a meaningful representative way, but I would also be more than happy for anyone who knows more to correct me on that particular issue. And then final question that I see here in the chat is, where can I find the guideline for the active debris removal technology development? I can certainly drop a link to the text of the Orbits Act here in the chat. So let me go ahead and do that real quickly. And then you can use this link to take a look at that Orbits Act, see what Congress is saying about it. And then again, there really is not a legally binding guideline for the development of this technology as of yet. Certainly not one that is passed by Congress. But again, check out the Orbits Act and you can kind of see Congress's thoughts on this particular matter. All right, and I think that that has largely brought us to the end of our program. I don't see any additional questions here in the chat box. So wanted to thank you all once again for attending the webinar this morning. Really appreciate your time and really appreciate the questions that have flown into the chat. If you have any additional questions that for whatever reason you didn't want to ask during the webinar itself, please feel free to email me there at my U.S. Air Force Academy email address that I've posted into the chat box. You can also find me just by, Googling United States Air Force Academy, Jeremy Grunert. That should have my official email attached to it as well. I would be more than happy to hear from you. So please, just let me know if you have any questions or if there's anything further you need from me or from the Law, Technology, and Warfare Research Cell in order to apply for CLE or anything else. We will be sending out a uniform certificate of attendance as well. And so again, if for whatever reason you're not on our mailing list, please just let me know, shoot me an email, and I will send you that uniform certificate of attendance to apply for CLE. And so with that, thank you so much. Have a wonderful rest of your day. Have a wonderful rest of your 2022. I hope that you have been having a safe and happy holiday season, and we look forward to welcoming you to our Law, Technology, and Warfare Research Cell events, and hopefully the United States Space Comm Legal Conference here in 2023. And so with that, I will be signing off. Thank you again for your time, and have a wonderful day.